no divestiture of Chrome or contingent divestiture of Android, because that was in there. Some data sharing, no exclusive agreements, some search syndication, meaning a search engine can basically provide results that just come straight from Google, right? They're mimicking Google. The surprising thing, though, here, and what was great for Apple, is that the judge said Google could continue to pay for search default positions. That's with Apple, with Mozilla. It pays some OEMs to pre-install Google Search on the Android phones that they manufacture. And that, I think, was a really big surprise.
How is this remedy consistent with the original ruling, with the original finding of the court?
You know, I actually have a really big problem with aligning those two things because I don't think that it is. In terms of no Chrome divestiture, I think it's very consistent. And Paul, you know, I've been on this show before, and I've been saying for 2 years that there would not be a Chrome divestiture ordered here. But where it's inconsistent is with this default position, because having a monopoly is not illegal, but it's the conduct that maintains the monopoly that's exclusionary that is illegal. And what the judge found in that liability decision, that the conduct that was illegal were the default agreements, right? This was exclusionary. This kept other search engines from being able to grow and scale and get better. He's allowing those default positions to stay in place. Now it's a shorter term. It's only for 1 year. Theoretically, in 1 year or 1 year after that, other search engines that have improved can compete for that contract. But it's still odd to me that what is found to be illegal is allowed to continue.
Well, the stock market likes it. This is a company that's got $2.8 trillion in market cap. And it's up 9% today. You just don't see that very often here. So what does this mean for just Silicon Valley in general? Can I sit back if I'm a CEO in Silicon Valley and say, the courts are maybe a little bit more aligned with our industry, how we think about the world, than maybe the government?
I would say that the way Silicon Valley can think about it is that this judge was cautious, and this judge did talk about needing to apply caution when you're dealing with tech markets and Silicon Valley companies, because judges don't understand it. They don't want to impact the route, the innovation, and the natural course of the industry, right? They don't want to distort that. And so it does suggest that it's more likely a judge is going to be cautious in future remedies for other cases. But what I think everybody has to keep in mind, because I've seen people talking about the fact that there's read-through for some of these other monopolization cases, I don't really think that there is, because the facts are entirely different case by case. The markets are entirely different. And what made a divestiture remedy inappropriate here doesn't necessarily exist as a fact pattern, let's say in FTC v. Meta or US DOJ v. Apple or the other DOJ case against Google in the ad tech space. Those are different cases with different facts. And I don't think that there's necessarily a read-through that companies are safe from divestiture orders because of this one.
Do we think that AI, the quickness and how it's developing, played any kind of role in the judge's decision here?
Oh, absolutely, 100%. The judge even observed that in the liability hearing, which was now a year and a half or so ago, that AI barely came up at all. Other than by Google, it barely came up. But in the remedies hearing, it was all about AI, and the witnesses were all AI. And he says it just shows in a year or year and a half how much things have changed, and the fact that you now have real competition to general search other than other general search engines. And I think that impacted him a lot.